Hello, everybody, and welcome back to another edition of NLD Stars. Today, I'm here with Jordan Butler of Spiros Law. I'm very happy to speak with him and about his and Samantha Sweeney's verdict from a couple of weeks ago in a motor vehicle accident case where they obtained an extraordinary result, jury verdict, in a historically conservative venue. Jordan, thanks for being with us.
Thank you. Thanks for having me.
And so, Jordan, let's jump right in. Tell us a little bit about the case, the facts, the venue, and then set the context for us.
Yeah, sure. So just to kind of paint a picture for everyone, this was a case that was venued in Vermilion County, which, as was mentioned, is a traditionally conservative county. Our clients were a family, the Parker family, and it was Edna Parker, David Parker, and their young daughter, Lindsay, at the time. And this crash occurred out on rural roadways, farm roads. And at the time, Miss Parker was taking her young daughter home from school, and they were headed home for dinner that evening. And they were just 0.6 miles away from their house when tragedy struck. And at that point, the defendant, who was a local farmer as well, blew a stop sign and T-boned their vehicle at a high rate of speed, throwing them into a nearby ditch and knocking them on their side. As a result of the impact of the collision itself, Miss Parker was instantly rendered unconscious, and her young daughter was conscious in the back seat, buckled up, screaming for her mother to wake up for several minutes. So eventually her mother did wake up, but was never the same person moving forward. They were rushed to the hospital, both of them, and Miss Parker had sustained several fractures, most saliently a sternum fracture, but as well as some other injuries, including a closed head injury. So from that point, she did continue to follow up with primary care for some regular checkups, and in about a month and a half to 2 months post collision, she began to experience more chronic headaches. And then from that point, she didn't really get in to see a neurologist for about 6 months or so afterward, but was nonetheless continuing to experience the chronic headaches, along with the neck pain and sequela from her fractures. However, she finally got in to see a neurologist after a lengthy period of time, and they began a course of trigger point injection treatments. And then eventually, the working diagnosis evolved into not only cervical headaches, but migraine headaches, which required a different alternative form of treatment with Emgality injections. So Ms. Parker essentially began receiving not only trigger point injections, but Emgality injections on a recurrent basis. And up till the day of trial, she was still receiving all of those injections on a regular basis. So for the case occurred in 2015, and essentially from the point that the lawsuit was filed, liability was completely disputed by the defense. And that was because neither Ms. Parker nor the defendant could have any independent recollection of the actual details of the collision itself. So the defense really hung on that fact to try to, create issues at trial that nobody could really point the finger at anybody, because there was no memory of exactly what happened. So
how did you clear that hurdle? I guess there was no police report saying that the stop sign was ran. If liability is contested, how did you deal with that? Both pre
yeah. So there, it was all circumstantial evidence. There was a report. The Vermilion County sheriffs came out to the scene that day and conducted their own investigation, and they did cite the defendant for failing to yield at that point. And so we felt like we had strong evidence in the way of liability, and we moved for summary judgment, and it was denied. barely, the judge said, but it was denied nonetheless. So, you know, our intent was to use circumstantial evidence as far as obviously the defendant was on a controlled roadway with a stop sign. Our client was not. The final resting location of the vehicles suggested the initial forces that were applied to the vehicles. And then, of course, where the damage was observed on the vehicles, we could have the officer testify the initial point of contact where that occurred between the vehicles and where in the intersection he thought that the collision itself occurred. And all of that stuff strongly suggested that the defendant either rolled through the stop sign or just did not stop at all, resulting in the collision.
And were you able to do that just with the responding officers? Did you have to get an accident reconstruction expert?
No, so we were able just to do that with the responding officer. There was quite a bit of briefing on the issue because we were using the officer both as a lay witness and an expert witness in the capacities that he had foundation to testify for. And in Illinois, there is good case law to support that police officers, as well as a number of other occupations, can serve as dual capacity witnesses. And so we felt comfortable with that. And, you know, but I think one of the things that would be important to highlight here is that the defense contested liability the entire time up until the weekend before trial. And the defense at that point moved to amend their pleadings to admit liability in an attempt to completely derail our trial strategy, because everything is worked up to point the finger at the defendant, right, and try to, you know, build up a case of holding him responsible for his actions, whereas that's really going to kind of change the perspective from the juror's eyes if he's coming and saying, "I understand this was my fault."
So how'd you handle the last minute attempted audible?
Well, we did anticipate it thanks to some guidance of some seasoned attorneys in my office who, you know, I smelled it coming. And so, you know, I had stuff ready to go. And, you know, it was just, I guess, essentially being ready for any possible alternative in that situation. And I think that is a key takeaway if you're in one of these factual circumstances and you don't have a summary judgment determination, but you feel the liability is pretty strong and it hasn't been stipulated yet, be ready for the defense to pull the rug out from underneath you at the last moment as just a kind of tactical gamesmanship move. And don't let them catch you sleeping in that regard. So that's the general context of how we got to trial. I believe, and I'd have to look at the exact numbers, but I believe the last offer before trial was $65,000, and then on the day of trial, they offered $90,000. My clients weren't interested in either of those whatsoever. Ms. Parker has her claim for negligence against the defendant, as well as for the medical bills they incurred on behalf of their minor daughter. The husband had a loss of consortium claim, as well as the medical bills that they incurred for the daughter. And then the daughter had an emotional distress, pain and suffering, loss of normal life negligence claim as well. And so I don't know if you kind of want to pivot to trial at this point, or
yeah. One thing I wanted to ask you specifically, given that you were in a conservative venue and the defense strategy shifted the weekend before trial, how did you approach voir dire? And what was your going in trying to set up your trial?
Sure. So I think the most important point I can make to voir dire is absolutely ensure that you have a voir dire team with you and that you're not going in alone with it, because there is so much information to digest in the moment that it really helps to have, the person that's asking the questions, but as well as your co-counsel listening, your client listening, and then any type of, assistant or staff that you might have. And so, I guess going into that, we had some preset voir dire questions specifically related to liability. And, that would kind of get us geared more towards the jurors who felt more heavily about making people feel or holding people responsible for their actions, and kind of just try to shift those voir dire questions, out of the process and get it geared more towards, a damages perspective. But I think we really got a leg up at trial at voir dire because the defense attorney took a stab at it completely by himself. And we had a team, as I just mentioned, and we were able to get one juror on there who had a traumatic brain injury, who the defense tried to backstrike and was unable to. So I think he inadvertently let that juror on, as well as just some other, plaintiff-friendly jurors that I don't think that they necessarily would have liked to have on if they would have been paying attention as closely as they wish they could have.
So when it came to trial, what were the biggest hurdles you had to overcome or obstacles that you had to deal with?
I would say that, just always be prepared for the unexpected, but then also because it's always going to happen. But the biggest hurdles is just the relentless amount of work that you've got to put into it to make the correct outcome, turn out. It's just a matter of doing exactly what it takes to make sure that you've left it all on the court, so to say, at the end of the day. And, I think constantly challenging ourselves individually to get to that point is in and of itself a hurdle, because we think we can only work so hard until you're really in the heat of it, and you can find out exactly how hard you really can work when you've got, your client's life and on the line, so to say. So I think that's kind of the biggest hurdle, is when you go into trial, you find out just, how hard you are able to push it to get the right outcome for your client at the end of the day.
It sounds like this was an in-person trial, but just to clarify, was it in person or on Zoom?
Yeah, no, so this was completely in person. I may be wrong, but I believe it was the first in-person civil jury trial they had since March of 2020.
Wow.
Maybe one or two, but it was interesting coming from, a mostly conservative county. Most of the jurors were not too concerned necessarily about masking protocols and whether fellow jurors and court staff were vaccinated and things of that nature. However, nonetheless, the court obviously has its rules and guidelines that it strictly adhered to. And it was an interesting aspect to have, COVID in the mix, because, for example, part of why our client, the plaintiff, had a minor delay in her ongoing medical treatment was she was afraid to return to her doctor because of COVID. She just wasn't willing to go back to an in-office meeting in mid 2020 because she, like the rest of us, was terrified of catching this and something happening. So that played to our favor. But at the same time, there's a lot of, I think, factors related to COVID that we as plaintiffs, attorneys, and trial attorneys haven't even started to account for, related to how it affects juries and how it affects how we should present our cases.
So, obviously, when it came down to it, yours was a trial that focused on damages. And you obviously had a fabulous result, having a verdict of over $250,000. What damages proof do you think resonated best with the jury that allowed you to obtain that kind of an award?
So I think highlighting at the very end of our case, our last witness was the client's ongoing treating pain management specialist, and he was really a rock star witness that we had prepared with really good demonstrative exhibits as far as the ongoing trigger point injections that she was going to have to receive for the rest of her life, the ongoing different types of medications that she's going to have to receive for the rest of her life. And just finding a good treating doctor who is relatable. He's not just a patient advocate, but it's just kind of a relatable human being that can speak to the jury and, wrapping that all up at the end, and then kind of, we used a CDC live table to give the jury kind of a per diem idea of, how they should calculate out those future damages. And so I think the way we really brought it home was, and we punched this in closing, she has had this many injections from the date of the collision until now. And you just heard the doctor say she's going to need this many, per month for this many years for the rest of her life. And it kind of just led the jury through a calculation of what they should do and what number they should provide. And I think, by the end of it, that they obviously agreed with us.
Wonderful. Before we go, do you have any other takeaways, lessons learned for all of us?
I would just say everyone believe in themselves and work as hard for your clients as you possibly can, because this was my first jury trial that I was first chairing, and obviously I was very nervous and reluctant about a lot of things, but that's where growth occurs, is in that uncomfortable spot. And if you just believe in yourself a little bit and you work as hard as you possibly can, then you're gonna feel okay with whatever result comes at the end of the day, and you're gonna grow for it too. So that's what I would leave you with.
Well, Jordan, you are off to a tremendous start. The Parker family was very privileged to have you and Samantha as their advocates and champions at trial. Congratulations on the result, and we look forward to seeing more big things from you soon.
Thank you, Jared. Thanks for taking this time to meet with me, and best of luck to everybody. Happy holidays.
Thanks. Leah, we can stop recording.